This episode of It's Your Call is one of a series dedicated to facing the mortgage crisis in Southern California, brought to you with the support of the Corporation for Public Broadcasting. Good evening, I'm your host Roger Bowman. On tonight's show, we'll deal with the reality of the mortgage crisis today, what programs have been proposed, what programs are not working, and what you as a homeowner can do to get your mortgage problem resolved. In the studio with me this evening are Alan Sims, CEO of the Center for Litigation and Consumer Real Estate Education, and James Cuzzolini, law student at California Southern Law School and a volunteer with CLCREE. I invite you to call with your questions of our guests. Our toll-free number is 866-367-5827. Now, before we get started with our guests, I'd like to let you know that KVCR has organized a mortgage crisis town hall meeting, and you are invited. Join us on Saturday, August 15th at 1 p.m. at the San Bernardino Library for 90 minutes of interactive discussion with the best of our local regional experts. Go to kvcr.org and click Facing the Mortgage Crisis to learn how to reserve your free seats. Gentlemen, thank you for being here. Alan, we've seen you once before, but I know you have a lot more to offer, and I'm looking forward to it. And James, your first time here, tell me, your organization, the acronym I gave, is actually the same one that Alan's a part of. Is that correct?
Correct. He's the CEO. I'm a volunteer for him.
Wonderful. And tell me, what motivated you in your first year of law school, I imagine that's a lot of work for you, to become a volunteer with Alan's organization?
Well, it's a part-time law still. Actually, I was involved in the home loan modification deal. I purchased a house in 2005 when the homes were at their peak, and I got to a point in my life and my career when I decided I couldn't take this anymore. I looked through the home loan modification options for myself. I looked at the home loan modification scammers and such like that. When I saw and found out what Alan was doing, I wanted to be a part of it. He offered me a position, I took it.
What was the resolution on your particular house, or what came about for you?
Eventually, 6 months later, I have a home loan modification.
So you basically won the game show. I mean, it seems so rare, and we're going to talk about that tonight. It seems so rare that people actually get a modification. Did you get a token one, or is it real? Did it really help you?
Well, as far as the principal balance reductions, statistically and in actuality, in my case, it didn't happen. Okay, only about 2% of the home loan modifications that actually happen, those folks have a 2% chance of getting a principal balance reduction. What it did do for me was lower the interest rate, take the option arm portion out of the loan, and it gave me a payment that made the home affordable.
So you can stay in your home.
Absolutely.
Now, was this a bank program, or was this a bank executing a federal program?
This was my bank. Washington Mutual was consumed by Chase, and this was their program.
And this was entirely of their own. It wasn't
Correct.
Making Home Affordable or one of the other government programs?
No.
So you actually had a good resolution.
Absolutely.
So we can't excoriate the banks entirely tonight.
No.
That's great, actually. This is what we want to help other viewers achieve. So that's why you're here. Thank you.
Thank you.
And Alan, tell me about your organization.
Well, the organization, as I mentioned last time, and thanks for having us on again, it was developed around myself being an expert witness. I'm a forensic real estate appraiser. Normally, I track the paperwork for legal cases that attorneys hire me for. I have seen so much within the last several years, and I just wanted to go ahead and make sure I could help the public out and bring that expertise to bear for a lot of people.
Wonderful. So what is your organization doing? Is it a for-profit, not-for-profit, and what's its status?
Right now, we're a not-for-profit organization. I filed my articles of incorporation with the state, have been approved. We're still working with IRS, but it takes some time. But in the meantime, I'm funding the nonprofit myself, and we're going to go ahead and do some exciting things with it now because we have to do something for the public. I can't wait around. And that's a good thing for us, and it's a good thing for the public because I think we have some good programs out here that's going to answer a lot of questions and get the homeowners back in the game again.
Okay, so you're open for business, essentially.
My website right now says August the 6th, but it's up tonight, and we're open for business.
Okay, close enough. For many of our viewers, I know that they've been waiting months to get action. Some people are involved with the scamsters. Tell me about your research into those people.
Home loan modification scammers are basically taking advantage of the desperate homeowner who's in the process going through the whole foreclosure deal, and basically what they're offering is a promise to fix, repair, anything under the sun in order to get your money up front instead of remitting those payments to the lenders and such like that.
So are you saying that this is where they want a fee up front, or are they trying to get you to pay your mortgage to them?
This is a boiler room with sales telemarketers where they promise you to get you things like principal balance reductions. They promise you to keep you in your home. They promise to give you your home for free through litigation services and through basic scam type procedures that typically, according to the Attorney General and to DAs across the country, don't work.
Now, we've heard that people should avoid some of these nonprofits that sound like they're affiliated with the Hope for Homeowners government program,
Absolutely.
but the fine print shows that they're not affiliated with the government, and other ways that they're using protective services. And so avoid those. And what people are doing instead, I believe, and I've heard, is that they're reaching out to attorneys, legitimate attorneys who, in that case, aren't necessarily telemarketing scamsters. But now there's problems with attorneys. Tell me about that.
Right. The problem that we're experiencing, and James can also comment on this, is the State Bar of California several months ago was getting at least 900 complaints against attorneys saying they're involved in this loan scam organizations out there. And what was happening was the mortgage brokers, the same people who got the homeowner in the bad loan in the first time, was soliciting all the lawyers out there, especially some new lawyers that James was telling me, come on in business here. We can get some upfront money because you can collect fees, and we will bring you more business so you can go ahead and help them with the loan modification. And you can't do that.
So, Alan, you've actually advocated, correct me if I'm wrong, not to pay upfront fees. But that doesn't apply to attorneys, because with an attorney, that's an exemption because generally you have to pay them a retainer, you have to pay them for their time.
You can pay your attorney an upfront fee, absolutely. He's entitled to it. As an expert witness, I ask for upfront fees also. But you just can't take the money and not do anything. That's the problem. The mortgage broker has formed a shell corporation, and sometimes they even have a P.O. box that dissolves over the weekend. To take this money, have an attorney believe it on the hook. Their attorney should know better than that. And they get involved with the situation, trying to make some fees, their attorneys are trying to do some good, but they get caught up in their scam themselves.
Okay, now I know you know a lot about modifications and you know a lot about phantom income and other things. So I want to get to that, but we already have calls. We have a lot of calls already, so I'm going to take the first one. Let's go out to Anaheim. Jesse, and to all my callers, please listen into the phone, not the television, and that'll make our calls go much better. So let's go out to Jesse of Anaheim. What's your question?
My question is, what is going to happen to me when I purchased the house? It was $700,000. I put it on a short sale 2 times. The second time now we're at about $350,000. Suppose somebody comes and buys it for $350,000. What happens to me? What is going to be my credit has been ruined? But what happens? I'm just wondering. Supposing somebody comes, buys the house at $350,000, then what?
Good question.
Usually right now, we heard the 1099-C. Some people get a 1099 when they work for someone. If they're not employed, they get a 1099. And what's happening is if you sign that short sale contract, make sure you read that tonight. And if they haven't bought it, and if they list that you will be charged the difference between what the house is worth and what they sell it for, I suggest strongly, unless you want to be on the hook for the difference, and also receive a 1099-C that shows income that you're going to have to pay taxes on. If the house is not in a contract, tear up that contract tonight and go find yourself another one.
Okay, so let's clarify that for people that aren't aware. When you short sale, you have to get the bank's permission, correct?
Absolutely.
So most of our viewers, I believe, are under the impression that once they short sale, problem resolved, they're done. Is that true?
Well, it's true, but you have to read the contract. It's not true if the contract says you're going to be responsible for their shortfall and you're going to get a 1099-C. Call your real estate agent up, call your bank up, and says, if this thing short sales, am I going to be charged the taxes for the difference as an income at the end of the year?
So if they sell it for $100,000 less than they owe, that's $100,000 of reportable income at their ordinary income tax bracket.
That's you.
And how can people avoid that? How can they not get hit with
They
that
have
tax?
to. They have to before they sign the contract, saying no, I don't want it. The bank's going to eat the difference.
And they will occasionally agree to that.
If they want to sell the house, yeah.
Okay. Let's take another call. Let's go out to Upland. Jim, you're on the line. What's your question?
Hello. Hi,
Yes.
my name is Jim. Thank you for taking my call. My question is, me and my wife, we bought a house 5 years ago. We have 2 kids. And at the time that we bought the house, I mean, we both have a good income. We are professional. But at the time we bought a house, and then the house went up. We had equity, almost $300,000 equity. You guys remember, about 3 years ago. And then now, everything went down. There is no equity. And for our different reason, we're going to a divorce situation. Now we're going to a divorce situation. She wants the house. And I said, well, we have 2 kids. We have 2 daughters. The benefit, I don't want to argue about anything. The main thing is the kids now. Okay, I will say.
So,
But on the house, the deed is in the both.
Jim,
the deed is on both
tell me
names.
what your question is, Jim.
Okay,
what
my
can our guest
question
answer?
my question is, if I said, okay, judge, she can have the house, can the bank will automatically get rid of the loan because the loan is on both of us' name? How can I get rid of the loan if I give her
Jim,
a house?
I understand. Alan, obviously somebody wants to recuse themselves from obligation
Absolutely.
of that.
They can do a quick claim on the deed.
Yeah, that would be an easy solution in a lot of cases on a lot of the homes, but when you bring divorce proceedings into that, I mean, this is a family law and an equity question and everything else. Theoretically, yeah, you could quit claim the deed and such, but in a situation of negative equity, I'm not sure if he has negative equity or not.
Well, it sounds like he has negative equity, and even on that, I just finished a divorce case myself, appraising a house. The biggest fight right now is who's going to get the house that's worth less.
Right,
Okay, I mean
right.
that's what the big it used to be several years ago.
Same
I want the
question,
house.
yeah.
Now you're going to get the house. Okay, and that's the big question here. As far as hopefully the caller has an attorney. And the first thing you have to do is common law. I mean, it's not common law, but it's community property here. They're going to be splitting what assets or what's left in the house. So contact your attorney and ask what the best recourse is.
Normally in a dissolution, you have to sell the asset when it's a large asset like a home and split the proceeds, and it's a bad time to sell. If they can afford the home and they can ideally recover from it, they wouldn't want to sell. But you mentioned quitclaim, James. Is a quitclaim a resolution for everybody that the bank doesn't have power to veto, or can the bank veto a quitclaim?
Absolutely not. And I'm not sure about the bank's revocation of a quitclaim.
Okay.
But the divorce proceedings are going to be different than what the bank's going to decide to do.
Right. Understood.
But again, have your caller contact an attorney. Let them decide how to split negative equity.
I understand. That's going to be a tough one. Okay, so let's go out to another caller, Palm Springs. Joanne, you're on the air. What's your question?
Hi. I have 2 questions, actually. One is about what is the difference between a short sale and a foreclosure? It seems to me that why go through the drama of for the short sale, waiting and waiting for the bank to make up their mind? Why not just walk away? That's one question. Number 2, if you do walk away and you have some assets, but you're so upside down on the equity of your house and the loan, the equity line that's attached to it, will the bank go after your assets?
Good question.
We have a one rule law here in California. Either you get the house or you get the cash, and the bank can't get both. But
they can't get both if they foreclose. Is that
if
right?
they foreclose, they get the house. They can't come after you for the cash. Now, that's only for purchase money, like your original mortgage, or if you took a second out, and that second, like an 80-20 loan, it was used for down payment to purchase the house. Now, if you took out a second loan after you purchased the house, read your contract again tonight. It's a personal guarantee. That means that Hummer you bought out in the parking lot, you're going to have to pay for because they're coming after you for that personal note.
Okay, so what you're saying is it true that if it's purchase money, first and second, and you short sale, then they get the house and not the cash?
Well, they get the house, but remember, we just answered that question at 1099. There is that difference on the short sale. Read that contract and see if you're going to be responsible.
Do you get the 1099-C if somebody is foreclosed on?
No. If that, either get the house or the cash. Either going after you for the house, or you keep the house, or either you keep the house or they want the cash. And right now it's a one rule law. Once they foreclose, the bank gets the house.
Oh, so they can't go after you. Joanne's question is valid.
Right.
Why not just wait and let them take the house? Why bother going through the short sale?
That's true. Well, don't you agree?
Absolutely. Well, in a lot of cases, people go through the short sale because they feel that it doesn't hurt their credit as much as the foreclosure.
Is that true?
I'm not a credit counselor, but I understand the best way to look at it is if you owe someone a secured debt or unsecured debt, it's going to whack your credit either way. You might want to ask who could probably answer that better than anybody. It could be a bankruptcy attorney, believe it or not. He's going to tell you the ultimate. If you have bankruptcy, that's going to ruin it this way, and if you have different levels of assets that are slipping away from you that you owe money on, it's going to hurt you different ways. So you might want to check a bankruptcy attorney.
All right,
and it's going to depend how much in assets you actually have, whether or not it would be worth it to go through a foreclosure proceeding versus a short sale proceeding. So and it's going to be up to
what we're hearing. Her answer is if she refinanced and that money is personally guaranteed, she's not absolved of that. They can go after her assets. Let's take another call. Let's go out to Moreno Valley. And Diane, you're on the air. What's your question?
Yes, it's regarding rental properties that I have in another state. And the renters, my mortgage payment is actually higher than my renters are renting for. And is there a way that I can get, work with my mortgage company or something to, because I can't refinance because it's upside down, of course, with the market. So what are my options, or what can I do to...
Good question, Diane. Okay, so I know of people in this situation. They have a home. As with many people, the rental income doesn't cover their mortgage, but they think, I'll hold on to that asset and it's appreciating in value. That's not the case now. So is there any option that the person has?
The lenders are interested in doing home loan modifications, even for non-owner occupied homes, especially in other states where their market isn't as hit as hard as it is in Southern California. When there's less of a loan-to-value difference, as such, like a place like Southern California where we're upside down 150%, they may only be upside down 40 or 80%. And the lenders and the banks are interested in making modifications even on non-owner occupied homes.
And especially if there's a cash flow coming in. Something is better than nothing. So go to your bank, tell them what you can afford, show them not a month-to-month rental, show them a long-term rental, at least a year. And put your rentals together and say, this is what I can afford, this is the cash coming in, this is guaranteed to me. They have a lease there for at least a year. And see what happens.
Okay, so what you're saying, James, and Alan in this case, is a little bit different than what a lot of people are hearing. You're saying that non-owner occupied homes are subject to modification, but not through any federal guaranteed or federal assistance program. Is that right? Those have to be owner occupied to qualify, such as making... Okay, so this would just be like your modification was, the bank's own initiative to avoid a foreclosure.
Correct. And there's going to be more to come on the non-owner occupied because they are seeing rentals go into foreclosure, and they are having to deal not only with the owner-occupied homes being foreclosed on, also these rental units being foreclosed on, and more families out on the streets, and more issues with that.
Okay, great. Let's go to another caller. Let's take Palm Desert. Jimmy, it's your call. What's your question?
Hello. Thank you for taking the call. Hello?
Yes, you're on the air.
I'm sorry. we had a foreclosure notice sent to us last December, and when I took it to my lawyer, he looked it up and found that it had not been recorded. And his assumption was that the lender may have lost the documents. It's gone through a number of lenders as in its history. And my question is what happens if the lender has lost the original documents?
I have not heard that one before. Alan?
They have, there's some cases in various states, and you read it on some of your log blogs you go on. A lot of times they're trying to, when they go in foreclosure, some actions are being filed, show me the original documents. I want to make sure I signed these documents, and they can't produce the documents. So on a technicality, it might be in limbo for a while. I would say that this is in limbo for a while, and if you're living there and you're not paying rent, but you're paying your utilities, you're paying everything else, you got a good deal right now.
So is this the Wonka golden ticket?
Yes, it is. It's a Wonka golden ticket right now.
So this person, prospectively, is in the unique position of being able to say, I want to keep the home, and it's your duty to get the documents or give me a like mortgage. Or perhaps even say, I'm upside down, I want to walk away, and I don't want you to hurt me in any way, and
sure.
They can't do anything about it.
Because they have to follow up with the first foreclosure, like we talked before, to make sure that he doesn't have any liability, because sometimes they walk away, the bank doesn't foreclose, you still have to contend with home insurance on it if it burns down and everything else. So if you live in a house, that's a good deal. Keep paying the electrical bill, pay whatever you need to do to make sure that you're not, the house is not abandoned, keep the grass cut and everything else, and wait for the bank.
Okay. Are there other cases where somebody might be able to actually, they're upside down, they want to get out, and they might be actually able to renege their contract?
Yeah.
You gave me an example that works for the Inland Empire residents quite well.
Yeah,
That's Spanish speaking.
The one example right now, and let's go down to, it's a California law. I don't have my sheet in front of you, but the long and short of it is real simple. You can go to legal aid and explain this to them. If you only speak a foreign language, just like Spanish, and the contract was in English, and you signed it, and you were never given a Spanish copy of the contract to know what you were doing, the contract being the mortgage, you can possibly have that mortgage rescinded. And just go to legal aid and explain that to them. They will look up the California law, and let's see what happens.
Now that's a very short sale.
That's a real short sale.
Now, in fact, that one is going to be similar to where you deed the home back to the bank. What is a deed in lieu of foreclosure? That's a similar case where they just take it back, isn't it?
Yeah, they do take it back. You hear a deed in lieu of foreclosure or a short sale prior to foreclosure. Some people say, well, the bank has agreed just to take the deed without going through the foreclosure, but you should have a separate contract saying, okay, you're not going to hold me responsible for anything else. This is it. With this deed, we're done. I'm walking out.
Okay, great. Now, let's go out to Riverside. And Robert, it's your call. What's your question? Robert, are you there?
Yeah,
Okay.
hello?
Yes, you're on the air.
Hi, I need to move away from Riverside for a job, and I've been advised to do a short sale. I'm worried that there could be a promissory note, or the bank might want to, get us for everything we got or whatever. But I just heard a previous question say that one of your answers was that a foreclosure might be better than a short sale. So my reason for leaving is because I have to move for work, but would it be better to just do a foreclosure?
Okay, so in that
Walk
case,
away.
Yep, similar question. And real quick, I just want to let Gabriel know I'm getting your question. Don't give up on us. Go ahead.
We're back to that 1099-C. If a short sale, again, first read the contract for the short sale. If they say you're going to be responsible, and if you don't understand the contract for the short sale, take it to either legal aid, pay an hour for an attorney, which I mentioned last time here, which is really good.
Absolutely.
And just see if you're going to be responsible for that difference. If you are, let it go in foreclosure, because you don't need that to follow you. It's going to really hurt your credit for the next 10 years.
Okay, great. And let's go out to Riverside. Gabriel, it's your turn. What's your question?
Yes. If a person files bankruptcy, will the mortgage company do the loan reduction or principal balance?
Good question. Can you get a modification if you go through a bankruptcy?
Yes, there's certain stipulations if you are in bankruptcy for loan modifications.
Now, is this just at the pleasure of the bank, or is this what we've heard about cram downs and the judge's ability to force it on the banks?
That I don't know. I know that obviously if you're looking or in the market for a home loan modification, the majority of the time they're looking to help seriously delinquent homeowners. Bankruptcy proceedings are commonly accompany or incidental to these sorts of situations where you are delinquent on your mortgage, home loans, the home equity lines, etc. And there are loan modification programs out there for people in just that situation, especially depending on circumstances, for instance, showing hardship and such.
Okay. And let's go out to Ronnie in Big Bear. It's your call. What's your question, Ronnie?
Yes, good evening. I've done work with Mr. Sims before in the past. He's always been a good guy, and he's done a lot of good work with me. And I went through a divorce here a few years back, and my wife and I had several properties together. And what we did is we ended up going through an attorney, and what she suggested was called a transfer grant deed, which legally divided up the properties between the two of us. One thing you need to be careful with, though, when you do this is that when you go to apply for a mortgage from a bank company and both your names are on the mortgage, even though you pursue the transfer grant deed, you're still liable for the mortgage because both of you have signed the mortgage. So what you need to do is make sure that if you have an attorney involved, that the attorney dots the I's and crosses the T's, showing that one is not responsible for the other's property, etc. But the thing is that I have refied the property which I received from the divorce, which took my ex-wife's name off of the note. But my ex-wife, one of the properties that she has, did not refi. So therefore, the mortgage note on that particular property still comes up on my credit report when I apply for anything.
Ouch, okay.
Right, I remember that case. I remember my pal up in Big Bear. Again, the attorney's going to have to separate that property. For our caller back in Upland, I believe. Yep. You have to go to an attorney on that, especially when you have the children involved in it and you have asset distribution, spousal support, and child support. You have to go to an attorney on that to get that resolved.
So, James, law student, what does somebody do if their attorney forgot to dot an I or cross a T? Are they susceptible, or can they go back to the law firm and say you didn't treat me right?
Hopefully they got good E&O insurance. Error and omission. Because I have to carry error emissions, attorneys carry error emissions. Hopefully there's no damage to the client. They would make it right, I would imagine.
Okay, great. Let's go out to Kathy in Riverside. It's your call. What's your question, Kathy?
Hi. Thank you for taking my call. My question concerns a second mortgage. I have every intention of staying in my home. I was able to negotiate a wonderful loan modification on my first. I sent an identical package to my second, which was IndyMac Bank at the time. We're going back to September of last year. I have not made a payment on my second mortgage in a year, and it's been turned over to a servicing company, Litton Loan Servicing. And I have been trying to contact them to try to negotiate possibly a loan modification with a second. I hear all this talk about the first, but I never hear anybody talking about what to do on a second mortgage. And I just started working after 16 months of being unemployed without any benefits. And now that I'm employed, I want to show good faith and work out some kind of an arrangement with them, but they're not even returning my phone calls. I just keep getting payment coupons in the mail.
Okay, Kathy, thank you. So what do you suggest in the case? Now, this is a servicer.
Sure.
So should she just bypass the servicer? This is on a second, though.
Yeah, absolutely. She should bypass the servicer in a way, but again, two questions on it. If the first and second is owned by the same bank, and she can renegotiate the first, and she's not paying on the second, the bank's going to have a hard time foreclosing on themselves.
Good tip. Now, that's not maybe her condition, but that might be some
But
people.
then the second right now is a junior lien owner. As long as she keeps the first current, and if the second wants to go ahead and foreclose on it, he has to buy out the first lien holder. So it's not like a Willy Wonka ticket, but what she should do is, again...
It's not... She said that she was interested in a loan modification, but that the loan servicer was not responsive. That's what a lot of homeowners I've seen on this show have said, that they've tried to do loan modifications themselves and they've been unable to do that. But I think part of the issue is that the loan modification process begins with the communication between the right people. Okay, and obviously you or the borrower signing on that loan is one of the right people. On the other side is going to be beyond the collections department to the loss mitigation section. They're the ones that are going to be handling things like loan modifications and negotiators and such. And the means of communication, the phone call, is going to open up the doors. But more or less, that's the beginning of the beginning. When you need to track your communications via email, it leaves an electronic signature and electronic receipt. Via certified mail return receipt. That's the sort of communications that the banks and the lenders need to see in order to get those processes beginning.
If she's with a servicer, can she simply ask who the title holder is, and are they obliged to tell her, well, indeed it's not us, it's this other person?
Well, I think on your last show, they mentioned that you need to get a hold of the servicer or the secured interest party that has filed with the Secretary of State on that money.
Mm-hmm. And another couple ways to do this is, again, she can call Hope for Homeowners on that program. You have their number on your website, I believe.
Yeah.
They can possibly research that for her and tell her who the lender is. Another thing she can do is go on the HUD website, and there's a letter there that a lot of people really, it's called RESPA. It's a Real Estate Settlement and Procedure Act, and they have a letter that you can pull back. It's almost filled out. And what she does is she gets this letter called a RESPA letter, but really it's called a Qualified Written Request Letter. It's on their website. She can go there. It's a sample letter. They have to respond in 20 days. At least they received it. And then they have to respond in writing within 60 days. And if they don't, then she can contact HUD, and HUD will ask the question, why aren't you talking to this homeowner?
Great advice. Okay. Let's go out to another caller. Let's go out to the city of Arleta. Sam, you're on the air. What's your question?
My question. Hello?
Yes, Sam, you're on the
air.
Yeah,
my question, I have the first and a second. My first is pretty much 100%, and the interest rate is 7.5%. And I was wondering, could I get a loan modification on the first?
Okay, the first in this case is a lower interest rate, right?
Right, and the second he had for what interest rates? I'm sorry.
7%, I believe.
7%. The loan modification, again, he has to ask the bank, start with the bank, possibly Hope for Homeowners again, because they will channel all that information between the first and second and see if he can qualify for that. Now, if he's going on a government program, remember we have this 80 to 105% rule here. You can't have more than 20% equity in the house, and you can't owe more than, your mortgage can't be above 5% than what the house, in other words, you can't be in upside down position for more than 5%.
Which has adjusted to, I think, 25%, has it not?
Even 25% is going to be hard here in California, okay? But right now, to my knowledge, they're trying to get it to 10%. You hear some, depends upon what the bank wants to do. It changes every day, as I mentioned before, okay? But contact the bank, tell them what you can afford, number one. How much payments a month you can afford. And let's see if they can meet your demand there.
So let me ask, some of the banks do it by extending your loan from 30 to 40 years.
Oh, we're laughing on this one.
That's a great idea, right? That's a loan modification.
Well,
absolutely.
Go ahead.
Well, first of all, lenders have performed loan modification and payment reduction on only 3% of seriously delinquent homeowners. Okay, so that means the majority of them have a fight ahead of them if they're interested in doing a loan modification. The loan modifications that they do include payment reductions by turning a 30-year loan into a 40-year loan, offering a lower interest rate for the first year, 4 years, and then bumping the interest rate back up. And then there's also the payment reductions that, as I said earlier, only 2% of that 3% are eligible for.
a minuscule amount. So of the 3% that get a loan modification, of those that have a modification where the payments are reduced appropriately, not token, because we hear about that, some of those, a percentage of those, are accomplished by extending the mortgage to 40 years.
Right.
It seems to me, since compounding interest works in your favor when you're an investor and works against you when you're a lender, that would cause you to pay a lot more for the same house, would it not?
Well, yes. I have an example. I always come prepared for your show here. Let's say you go from 30 to 40 years. And that's a good, well, I'm going to help you out here. That means the $200,000 mortgage you currently have at 6%, you just extended it out, will cost you additional $132,000 for that extra 10 years.
An additional.
That's a good deal, isn't it?
Plus, you have to make up the declined property value that you saw.
Yeah. There you go.
Absolutely, it is. I mean, but if the majority of loan modifications are just that, that's all it is. That they reduce the payment by extending the period of the loan.
Because they don't want to foreclose, the bank doesn't, and you don't want the credit hit, so you're willing to pay $135,000 to avoid that credit hit.
Absolutely. You're able to do it, and then they're not taking a whack on the bank is not taking a hit on their investment. They can repackage that and sell it as a performing loan, not for 30 years, but for 40 years.
Hopefully it's a derivative packaged up and
there
sold
you
as
go.
a CDO.
There you go. They're all set
the cycle
to go.
all over again.
They're all set.
Let's take another call. Let's go out to, how about Moreno Valley? Sabrina, you're on the air. What's your question, Sabrina?
Hi, my name is Sabrina, and I was listening to your program. And
Sabrina, what's your question?
Oh, I'm sorry. The question is that currently I have an 80-20 Freddie Mac loan, and I'm current on my credit, and I generally try to make the payment. However, I'm having hardship, so I'm struggling to make the payment. And I wanted to know, are the banks required to help homeowners who are upside down to modify or do a refinance?
Good question. Before you answer, I just want to let our guests know, and Sabrina, I know this is common, do turn down your television once you're on the line with our screener and listen into your phone, and you'll be able to hear us and answer right away. That's for all of our callers. Alan, go ahead and answer Sabrina's question.
These 80-20 loans are when people purchase the house with 80% normal mortgage. The other 20% was a second for the down payment. It was a no money loan, or it was a no money loan to purchase the house. If it's Fannie Mae or Freddie Mac, first has to own the loan. If they do, you pass the first criteria. The second criteria is, let's go ahead and see the value of that home. Is it that 80 to maybe 105 or 125% limit you have on how much you own on the home? And then after that, can you afford the new payment terms? And to do that, this young lady sounds like she's a prime candidate to call Hope for Homeowners and get that started tonight.
And some of the information that you said is on the makinghomeaffordable.gov site.
And I also have how to do your own modification. It doesn't cost you anything. What, about 7 or 8 pages, I think. On our website, you can just load it right down, and it will tell you step by step everybody you have to contact on it, and you can do your own thing.
Okay, and for our viewers, a couple of days after this airs, we get it on YouTube and posted on our website. You can click on KVCR.org, see a rebroadcast. You can watch the entire hour if you want. And in that same page, you'll find some of the links that we're talking about tonight. We'll get them on there for you. Let's go out to, in this case, Corona. Jesse, you're on the air. What's your question?
Let's go out to, in this case, Corona. Jesse, you're on the air.
Well, my question is that I actually missed part of the provenance deed in lieu of the property. And the reason why I'm going that way is because I try to modify on a loan that is current. And I'm from California, so I'm working with the state with the hardship of wage reduction. And no one will touch me because I'm current. And so then I decided on deed in lieu of property. Will that affect my credit, and what really deed in lieu of property mean? Because
good question. And I just want to remind our viewers, turn your television down. It comes over your phones. Once you're on the line with us, waiting for your call, we're getting to you as soon as we can. So, Alan, tell us about the fact first, we've heard this a lot. If you're current, the banks don't give you the time of day.
The Federal Reserve did a study looking at and scrutinizing home loan modifications and why more lenders and more banks aren't doing them. Everybody wants a home loan modification, whether or not you have a hardship, you're seriously delinquent, or you have no hardships and are completely current on your loan. The banks have found that their best solution to the current issue is to follow their procedures, the foreclosure proceedings, etc., and the homeowners correct the issues that they have themselves.
So it's a matter of chicken, and the homeowners blink first.
Absolutely,
Exactly.
absolutely. That statistics, I think you can go on. We will have that link here, but it was the Federal Reserve Bank of Boston, and I have it right here. And what happens on this? The bank plays a game. Is it going to be in our best interest to our investors to either foreclose on the property, or is it going to be or to do nothing? Right now, 30% of the people who are 60 days late, they correct their own problem. That's the highest success rate of any program, which means the homeowners are correcting their own problem by either going out and maybe getting another job, or going out and making sure that they adjust their budget a little bit better.
We've heard people getting roommates.
That's it. Roommates, the same thing. And the banks are looking for you to do that. And it's a shame. You know, as a consumer, that you're going to have problems in the future. Shouldn't you be getting a break on this and saying, look, I want to do something now, but the bank doesn't say, oh, no, you signed a contract. You're into this.
So are there anybody that's still current who knows that they're going to be hitting a hardship that are getting a loan modification, or are we seeing for the most part they have to get behind, even though they're not supposed to, that the banks just don't pay attention?
3% of seriously delinquent
There you go. There you go.
are getting home loan modifications. So
that means that means that if you're not seriously delinquent, the percentage must fall to inconsequential.
Yeah, it does.
That would be my guess.
It does. I mean, it seems like everyone's just shuffling the paper on this. And if you're a responsible consumer, but you know that maybe your job is going to be going away from you, or you got some tough times coming on, or anything like this, you're still good in the bank's eyes until you're 60 or 90 days late.
Okay, let's jump out to another call. Let's take Rialto. Ann, it's your call. What's your question?
Yes. My mom passed away 3 years ago, and I'm living in the house, but I'm still paying the mortgage company. And I tried to get the note turned over into my name, but the medical bills are holding us back. And they're saying they won't. That's the only thing that's holding me from turning the house over into my name. But we're still paying the note in her name.
And what's the goal you're trying to achieve?
Get the house turned over into my name.
Okay.
And modify the loan.
All right, thank you, Ann.
Yeah, and I would say one of the first steps she has to do is find a good probate attorney and see if the estate had responsibility passed on from mother to the note, or did the estate give her the property? Did it have any equity in it at the time? It was 3 years ago. The property could have equity at that time, and the estate could have refinanced. You know, there's a lot of different things that could have happened.
I want to make sure, because you turned just as you were saying it, and I want to make sure it got into the microphone. The advice is for her to find who?
A probate attorney.
Perfect.
And the best, if she's in San Bernardino County or Riverside County, call the local bar, the bar association. They have a referral service there, and they will get her involved in probate attorney. Ask the probate attorney, do they have a free hour of consultation? If not, pay for 1 hour of their service to answer that question.
Wonderful. Okay, so let's go out to Beaumont. Marcy, thank you for holding. What's your question?
Hi. I was wondering, I'm getting lots of solicitations regarding loan modifications, and I was wondering if I should respond to those because I am interested in a loan modification.
Okay, thank you. This is what we hear a lot.
Where do we start?
Give us the short answer.
Okay.
Typically, the for-profit or for-fee loan modification programs are not looking in or are representing you in your best interest.
They are not.
They are not. Typically, ways to avoid things like loan modification scams are ignore phone and mail solicitations. Ignore the fee up front. Pay attention to your instincts. There are folks out there such as HUD and Hope for Homeowners that are offering these programs for free. There are borrowers and lenders that are offering these programs for free. If you feel the need to pay for them, you need to do your research.
And this is an area where I have some personal experience, and a lot of our guests have talked about it. The people that want to make money off of you and not provide a service back, the scamsters, they pay a small fee to get a list of people that are delinquent, and then they pay to telemarket or send solicitations. The legitimate not-for-profits have a lot of staff members that are donating their time and expertise and are providing a free service to you, but they don't pay to call you and to send mail to you. You have to reach them. So the number one way, for instance, you can go to kvcr.org, click on the Facing the Mortgage Crisis button, and on that website that you'll see about Facing the Mortgage Crisis, you can go to counties of the Inland Empire or counties of LA or Orange, wherever you are, and find the list of HUD-approved counselors. Every one of those will give you counseling for free about what you can do to save your house.
Absolutely right. Absolutely right. If I could tonight, I would tell everybody, do not pay a loan modification company anything from now on. There's statistics on it, and especially I've been telling people since December of 2008 on a TV show up in Big Bear Lake every Monday, do not pay anybody, get your money back. And that's something we're very concerned with, about getting your money back with our nonprofit.
But those can be scary letters that tell you all the dire things that are going to happen if you don't call them right away.
Absolutely.
And
Absolutely.
They sell on their marketing platform is we get all or most or many of our clients' principal balance reductions. We offer 100% money back guarantee.
And it's in writing. It must be true, right?
But because the Attorney General and county DAs have open season on these loan modification scammers, these guys are really the here today, gone tomorrow sort of organizations. And the same guys that did your loan modification and took your upfront fees today may have been put out of business and are doing the same exact business under a new name today.
Okay, so I'm going to jump out to another caller. I knew this would be a busy night. Let's go to Palm Desert. And Lionel, you're on the air. What's your question?
My question, I really have two, if I might. I'll try to make them quick. I am 72 years old, 2 homes, one in Palm Desert, one in Manhattan Beach, where my daughter lives with her 3 children. Both are in the process of foreclosure, and I wonder, while I may not need to worry about it at 72, what obligations do I incur as a result of a foreclosure?
Okay, good question. I imagine the obligations are what we discussed before, either residual debt or tax implications.
That's it.
Or credit.
Or credit. And right now, if either house, it doesn't matter if he has one. Now, if he has 2 houses and one of the houses is a second home, I know we talked before where we were hoping to get the cram down through Congress, but he has an option to go to bankruptcy on it and do a cram down on one of his second houses. You can't do a cram down, even with our existing laws, on your primary house. That's what we're trying to do in Congress.
Alan, I'm sorry, you just took me aback a moment.
Yeah,
here.
I did.
You're saying that cram downs are not allowed on your primary residence, but they are on a second home.
Absolutely.
But cram downs are what everybody wants. That's forced principal reduction.
But that's what we wanted to do, but it's not available on your primary residence.
It's always been most people want to keep. So why not?
Absolutely, but it's always been available to the consumer out there under current bankruptcy law, that they could have their investment property, their second home, to be as a chapter for reorganization and bankruptcy. I have done many appraisals for cram downs on second homes. And businesses. I mean, that's what they do with reorganization. Look what they did with GM, the same thing. When they do a cram down, we look at the current market value, and then we look at your repayment policy that you can make that work for you.
Okay, so you know what? I'm going to take another call. Let's go to Upland. Let's go to Jim. Jim, you're on the air. What's your question?
Let's go to Jim. Jim, you're on the air. What's your question?
Well, it's not. Let me turn the TV off. It's
Thank
not
you,
a
Jim.
question. I already asked a question, and you responded. I just want to say thank you. And I have one comment, which is you guys are so good. You're helping so many people. And the next workshop, I guess you guys said you have somewhere a workshop in San Bernardino, and I have a lot of family, co-worker, and a lot of my country that I came from. A lot of in Los Angeles. I will bring them. And one question I have, if this show will broadcast in LA County also, because there are a lot of people are suffering the same thing in this issue.
Jim, I love your comments, but I'm going to cut you off because I have so many other callers that have a question, and I have great guests. But thank you very much. Don't forget our town hall. I'm going out to Victorville. Sherry, it's your call. What's your question?
Hello?
Yes, Sherry, you're on the air.
My husband and I currently own 3 homes in the Victorville Barstow area. We're current on all 3 of them. The question I have is, how do we go about getting our property taxes reduced now that our homes aren't worth the value that they were a few years ago?
Good question. Sherry, what county is Victorville in? Or do you know?
San Bernardino.
Proposition 8.
Proposition 8. You go to your local assessor in Victorville, or you can go online with the assessor, San Bernardino County assessor.
Online is super easy.
It is.
So long as you have your parcel numbers and such, you can go online, and if it hasn't already been done, because Larry Ward and a lot of the folks have already done assessments and reduced those tax liabilities on a lot of the properties already.
About 25%.
Yeah, and you can also, if they've already done it, but you think that your property is now worth less, then you can appeal that, and then you can appeal that process as well.
And I understand these websites, both for Riverside and San Bernardino, these websites, unlike government's normal operations, they're user-friendly, and the forms are straightforward. You don't need an extra service. It's inexpensive, if not free, and it's easy to do.
Absolutely.
Right. Okay, so that's one where we can give people hope.
Yeah, we can.
There's hope for homeowners.
And hope for homeowners.
Okay, running out of time, I'm going to go out to Indio and take, I believe it's Mariah. You're on the air. What's your question?
Hi. I was calling because I was calling because I lost my home with a foreclosure, and I had a first and a second mortgage, and I tried to deal with the banks trying to get a modification, and it was just really difficult. And I hired people that burned me twice, and the second one's with attorneys, and they also couldn't help me, because then somebody appeared in my doorstep saying I had to move because they had bought the home. So now that I lost, and this was like a 2-year process, and now that I lost it, I thought that I didn't have to pay anything, and now they're charging me on the second mortgage, and I've been faithful paying that.
Yep.
But
right. Yep.
But my question is, do I have to continue paying it or what?
Good question. Talk about recourse versus non-recourse, and the second that's exempt that gets washed away in the foreclosure versus, say, a HELOC. Tell our viewers.
Well, again, this is where we go back to the personal guarantee. It's a personal guarantee loan. And if you have a second that was not purchase money, again, it's all deals with purchase money, or if you can prove that money that you took out was for a home improvement, such as a new kitchen or a new roof or any improvement on the home, then you can go ahead and you can contact HUD. They have various programs there that you can go ahead and identify that second loan as a home improvement loan. It's just like a HELOC loan, okay? The strings are attached that it has to be for home improvement. If it's a personal guarantee.
So if it's home improvement or original purchase money second, then it gets coupled with the first in the foreclosure and washed away.
Well, it might not get coupled with the first, but at least you can explain it so that you're not going to be eligible for that in tax purposes and one in with IRS.
Okay. And there is a distinction here between owing tax on the phantom income after a foreclosure versus actually still owing the principal debt.
Absolutely, absolutely. I would ask for a copy of the original loan agreement.
I'm going to cut you off.
Okay.
I need to go out. I'm sorry to say. I'd like to thank our guests, Alan and James, for joining us this evening, and thank you for watching and calling. We appreciate our viewers. If you'd like to learn more about tonight's show and about how to save your home, and don't forget the town hall, be sure to go to kvcr.org and look for those free seats to our August 15th town hall at the San Bernardino Library. Watch us next week, and we'll see you. I'm Roger Bowman. Remember, it's your call.
For more information about this project and related topics, visit kvcr.org and click on Facing the Mortgage Crisis.